Judge, may I address bond briefly?
Okay.
Mr. Dillard is the sole provider of, he's got 4 kids, ages 2 to 13. He would like to get back to his job at construction. He could live with his mother in Belleville. He will have no contact with the victim, who is the mother of the 4 kids. That being said, Your Honor, we're asking that the court reduce the $25,000 bond, which I believe set in both cases substantially. We'd ask that PR bond released if need be.
Judge, these are cases that happen within a day from each other. On June 9th, and June 10th, the same victim. The 13-year-old child was present. She was the one that actually called 911 in this case. There are obviously serious allegations involving a weapon that he brandished during the DV situation. So I believe bond is reasonable. We had originally asked for a $100,000 bond each case. A $25,000 bond was granted. So we have to keep the same.
Judge, just very briefly, it's almost the same incident, Your Honor. Again, I'm not minimizing 2 charges, but it just carried over to the next day. And I believe the weapon was licensed to the victim. All that being said, Judge, we're asking that he be able to support his kids.
And its motion for bond reduction is denied. Bond will continue. Preliminary examination will be set July 2nd, 2024, 9 a.m. before Judge Washington.
This from the heart. This
Judge, I know you've made your decision, but my client is asking me to ask you again. He promises not to have any contact with the victim.
but I'll be
Whatever you're going to say, what are you going to say?
Judge. I know you all know me, and the situation at hand. I just want to go backwards. I made a lot of strides through here. Not be in this position. I worked real hard not to even be coming back to the situation. If you can just grant me house arrest, other something, I'll be in jail. It's like
Here's what I know, and you're right, I don't know you. Here's what I know. The allegations that have come before the court is that there is a domestic violence situation which precipitated itself or continued into another day and involved a firearm. That's what I know.
You're not.
It never involved.
Judge, for what it's worth, a firearm was found. There was no evidence that a firearm was pointed at anybody. It's just that a firearm was found, which
is it was brandished.
Oh,
Judge, I don't believe that at all.
It was found.
It was simply found that the weapon was licensed to the victim.
My ruling stays.
I'm sorry?
My ruling stays.
Thanks, Judge.
Oh, you want me to change it?
Oh,
I will do more than that if you want me to.
Thank you, Judge. We appreciate it.
Yes, I'm serious. Dead serious. Are you serious? No, he's lucky I had water because that could have gotten bad. Thank you, Ann. Court called. What's the temperature? 77 right now. It's going to get to 90, right? And you would admit I'm a human being. I am. And that a human being needs water on a hot day. No, I'm just saying, no, if any of that is untrue, just let me know. Okay. All right. So if everybody knows if I fall out, it's because nobody gave me water. No, not talking to you. What? It is. Right? Doesn't matter. Still needs water. You didn't care either. Never mind. Never mind. No, I'm just gonna sit up here and just melt. I'll be fine. I'll do what I can. Court calls the case. People versus Jeffrey Shue. No, it's not there. There's no water. There's nothing. No moisture up here whatsoever. Except in the air.
Good morning, Your Honor.
Oh,
Christina
boy. And then she
Constantino.
shows up. I have no water.
I would have brought you water,
Constantino's here.
Judge. I would have brought you water.
I know you would have. I don't know about my staff. Go ahead.
Christina Constantino on behalf of Jeffrey Shue. Mr. Shue, can you state your name for the record?
Thank you.
And
Two, Alan. Two.
you'll be extra
Thank you.
hydrated. Good. Extra hydrated.
Go
Judge, is
ahead.
the date and time set for a PCC. We are asking at this time to have this matter set for a preliminary examination. It's my understanding that discovery is complete.
All right. Would people have their witnesses available on the 2nd?
I believe so, Your Honor.
Judge, is it at all possible to do the following week?
Now that I have water, maybe.
Thank God for the water.
Preliminary examination, July 9th, 2024, 9 a.m. That's in person before me.
Wonderful.
Oh, joy.
I'll bring an extra water with me.
Yeah, okay. Thank you.
Thank you, Judge.
Thank you.
This courtroom proceeding centers on a bond reduction request in a domestic violence case involving Mr. Dillard. Defense counsel addressed the court and emphasized the defendant's personal circumstances, stating that Mr. Dillard is the sole provider for his 4 children, ranging in age from 2 to 13. Counsel explained that Mr. Dillard works in construction and wished to return to his job, proposing that he could reside with his mother in Belleville if released. The defense further assured the court that Mr. Dillard would have no contact with the alleged victim, who is also the mother of his children. Based on these representations, the defense requested a substantial reduction of the existing $25,000 bond in both pending cases, asking for release on personal recognizance or, alternatively, release with a tether. The prosecution opposed the request, outlining the seriousness of the allegations. The prosecutor explained that the incidents occurred on consecutive days in June and involved domestic violence, with a 13-year-old child present during one of the incidents. The child reportedly contacted emergency services, which heightened the gravity of the situation. The prosecution further stated that the allegations included the presence and alleged brandishing of a firearm during the domestic dispute, making bond reduction inappropriate. While the prosecution acknowledged that the original bond request had been $100,000, it maintained that the $25,000 bond already represented a reduction and remained reasonable under the circumstances. Defense counsel briefly responded, arguing that the charges arose from what was essentially the same incident extending into the following day, and stressed that the firearm in question was legally licensed to the victim, not the defendant. Counsel reiterated that the defense was not minimizing the seriousness of the charges, but urged the court to consider Mr. Dillard's role as a father and provider. Despite these arguments, the court denied the motion for bond reduction, ruling that the bond would remain unchanged. The court then scheduled the preliminary examination for July 2, 2024. At 9 a.m. before a different judge after the ruling, defense counsel attempted to make an additional request on behalf of the defendant. The judge allowed the defendant to speak briefly, but made clear that the ruling had already been made. Mr. Dillard addressed the court emotionally, stating that he had worked hard to avoid being in such a situation and expressing regret over his circumstances. He asked the court to consider his situation and implied that he did not intend harm. The judge responded firmly, stating that while the court did not know the defendant personally, it had to rely on the allegations before it specifically. Allegations of domestic violence spanning multiple days and involving a firearm. The judge rejected the defendant's attempt to minimize the firearm issue, emphasizing that the presence of a weapon in a domestic violence context was significant regardless of ownership. The judge stated unequivocally that the ruling would stand and cautioned that further argument could result in more severe consequences. effectively ending the discussion on bond following the bond decision. The courtroom atmosphere shifted as the judge addressed unrelated matters while maintaining firm control of proceedings. The judge made several remarks underscoring courtroom decorum, personal accountability, and professionalism, using humor and candid commentary to manage the docket while reinforcing authority. The judge emphasized the importance of order in the courtroom, even making light references to the heat and the need for water, underscoring that while the court is presided over by human beings, judicial decisions are grounded in law and responsibility rather than emotion. The court then called the next case. People versus Jeffrey Shu, defense counsel entered an appearance and confirmed that the matter was scheduled for a probable cause conference. Counsel requested that the case be set for a preliminary examination, noting that discovery was complete. The court inquired whether the prosecution would have witnesses available on the initially proposed date. After brief discussion, scheduling adjustments were made to accommodate availability. The judge agreed to set the preliminary examination for July 9, 2024. At 9 a.m., to be held in person before the same judge. Throughout this portion of the hearing, the judge balanced efficiency with clarity, ensuring that both parties understood the schedule and expectations. The judge reiterated the importance of preparedness for preliminary examinations, particularly with respect to witness availability and discovery completion. The interaction reflected routine criminal procedure, but also highlighted the court's emphasis on moving cases forward without unnecessary delay. The session concluded with acknowledgments from counsel and light exchanges reinforcing the judge's authority while maintaining courtroom order. No substantive rulings beyond scheduling were made in the latter portion of the hearing. The court ensured that all parties were aware of the next court date and adjourned the matter accordingly, bringing the proceedings to a close in an orderly and controlled manner.
Your name, sir?
Devin Miller.
All right. And Ms. Mahmood, is she here or no?
Yes, she is here, but I think she's having some difficulties right now.
Your Honor, we haven't received a payment since the last time we were here. It's $26.65 total.
And sir?
$25.65, I'm sorry.
25.
So I recently just received employment, so I've been waiting for my check to come between that time.
But it's not going to be. I have a note that $1,000 was going to be paid. I don't know why.
$1,000?
Okay. Well, how would you intend on getting this paid off, sir?
So I don't get paid until the 28th.
Until the what?
The 28th of June.
Okay, but all right, let's take that. And how much would you be willing? How much are you going to be able to pay?
So with me working weekly, I get paid $5.60 on a full.
On a full check, you get how much?
$5.60 minus tax.
Because I don't know how we're going to do this if she's not here, because I'm about to. I mean, my inclination is to issue a judgment.
Well, we've been having some difficulties in being uncooperative.
Pardon?
She was being uncooperative. I would hope that you don't throw it out because I'm really trying.
She was being uncooperative.
I apologize for interrupting. I have an IM out front, but she doesn't want to come into the courtroom because of a contact order between her and her husband.
We don't have one, sir, Your Honor.
Are you her husband?
Yes. May I explain?
Please.
Okay, so recently she's having a spat with me. She's just upset that she wanted me to apologize for a misunderstanding that we had before coming here to court. When she got verbally volatile with me, so she decided to do that.
Okay. That's fine. Is there a no contact order between the two of you?
No, there's absolutely not. She probably just said that just to make things worse on my end.
Well, they couldn't get much worse.
Yeah, I don't.
I'm not really sure. She can be very vindictive.
Okay, so let's not say that out loud.
Okay.
Can you go down the hall and
Sign her into Zoom?
no? She's here. Yeah, well, ask her if she's going to participate in the hearing. You have one case, Mr. Friedman. Just say it.
I did have one recently, Your Honor, in 14A1 or 14B, I mean, and the person was adamant that he could not pay. And the judge finally said, well, okay, but you're going to have a judgment. And guess what happened 3 days later?
Yes. Hey.
So I know that advice of right says you don't have to have a judgment to get assistance, but sometimes it assists.
Sometimes it helps. Yep.
Is Miss Martin working?
She receives assistance. So, I recently started.
Pardon?
I recently started working.
Yeah, but does she work?
She doesn't work now, but she's disabled.
Disabled.
Yes. So she receives assistance.
I thought she was getting I didn't mean to, but I thought she was getting a job on the street.
Oh yeah, she was trying to get a job at Insomniac Cookies. She has yet to hear from them. But I was able to obtain employment, and I started working this week.
Where'd Alan go? All right. There's a total amount of $25,65 owing. Was there a method by which you were intending on getting this paid? Or do you know?
I'm gonna be very honest with you, Judge.
Okay.
I have no intention of paying one penny. No intention of paying 1 penny. I've been with Barnes and Barnes for since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed me. I've been begging Barnes and Barnes to fix my house for a simple fan for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together. And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March I was in jail for beating him up. I'm not going to stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not. He claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted, and I'm done.
Okay. I just had to make sure, which is why I wanted you in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue on a judgment for possession and money except you requested. For possession and money as to both defendants. Total amount, the 25,600, that was inclusive of cost, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. All right, thank you.
Sorry, could you say that again? I speak 3 different languages. I'm not American, I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir.
No, I'm
I'm
not-
mentally,
ma'am,
I'm
all right.
in middle school. I didn't pass, I
Okay.
speak 3 different languages. I'm not educated.
Okay,
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises
Okay, so
unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point, you can move by then or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
yeah, and I know how the eviction process works. I just don't. I have lawyers in my family, but I'm more on the medical side rather than the lawyer side. But I appreciate all your help, and so
All right.
my husband and I aren't cooperating today.
Thank you.
Thank you, Your Honor.
This court hearing revolves around a landlord-tenant eviction case where unpaid rent has accumulated to a total amount of $2,565, and the judge is required to decide whether to issue a judgment for possession and money. At the start of the hearing, the male tenant appears before the court and explains that his wife is present in the building but refuses to enter the courtroom, claiming there is a no-contact order between them, which the judge quickly clarifies does not exist. The landlord's representative informs the court that no payment has been received since the last court date and that the outstanding balance remains unchanged. The judge then questions the male tenant about his ability to pay, and the tenant explains that he recently obtained a job and is waiting for his paycheck, stating that he earns approximately $560 per week, but admits that he has not yet made any payments toward the debt. The judge expresses concern about the lack of a concrete payment plan and indicates that without cooperation or progress, the court is inclined to issue a judgment. When the female tenant is finally allowed to speak, the tone of the hearing shifts dramatically as she delivers a long, emotional statement declaring that she has absolutely no intention of paying any of the money owed. She explains that she has lived in properties managed by the same landlord company for several years and feels completely failed by them, claiming that repeated maintenance issues were ignored, including serious problems such as lack of proper heating during winter, which forced her to spend her own limited money just to survive. She states that she feels abandoned not only by the landlord but also by the police and the legal system, describing herself as exhausted, frustrated, hopeless, and mentally overwhelmed. She openly admits that she would rather sleep in her car than continue fighting for a home that she believes was never properly maintained. The female tenant also reveals severe personal struggles, including ongoing marital conflict, explaining that she and her husband are not standing together because she does not feel safe or emotionally stable around him. She discloses that she was jailed in March due to a domestic incident and says she is trying to avoid further confrontation or emotional breakdowns. Throughout her statement, she repeatedly emphasizes that she is done fighting, done arguing, and no longer has the energy to continue battling landlords, courts, or anyone else. After hearing both sides, the judge calmly but firmly explains that the court must make its decision based on the law and the facts, not on emotional hardship alone, The judge states that there is no valid legal dispute requiring a trial, since the tenants have clearly acknowledged non-payment and have not proposed any realistic plan to resolve the debt. As a result, the court issues a judgment in favor of the landlord for both possession of the property and the full monetary amount of $2,565 inclusive of costs. The judge orders that if the total amount is not paid by July 1st, the landlord will be legally allowed to request a writ of restitution, which would authorize law enforcement officers or court officials to remove the tenants from the property physically. When the female tenant expresses confusion and frustration over legal terminology, asking the judge to speak like to a toddler, the judge patiently explains the eviction process in very simple terms, stating that if the money is not paid or the tenants do not move out by the deadline, officers will come to the home and force them to leave. The judge makes it clear that this outcome is not personal, but a direct result of unpaid rent and lack of cooperation. The hearing concludes with the judge confirming the eviction timeline, explaining the consequences one final time, and formally closing the case, leaving the tenants with a clear but difficult choice: either pay the full amount by the deadline or face eviction enforced by the court.
13A District Court for County of Washington, State of Michigan is now in session. The District Court will draw near. The Honorable Judge J. Cedric Simpson preside.
You may be seated. My apologies for retarding this, folks. Pardon? Can you do what? Who are you? I think she is representing you. And so what would you like me to do? Well, I'm looking at you, but you mean call your case?
Yes, sir.
You have an attorney.
Yes, but
It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney.
she's playing on another case.
You know what? You can go out there and tell Miss Bauer, go out there, tell Miss Bauer that you fired him, then you come back in and you can represent yourself as soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Ping. I will deal with you in a moment. You don't want to deal with me right this second. Court is standing in recess.
All rise.
I'm having to address bond for his.
Yes, go ahead.
He has been contacting the victim. In this case, we also ask you to report his jail phone call privileges. He's made he's called her 195 times.
What?
Yes, and
Did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer, and that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey. Oh, no, we're not going to say that here. Phone privileges are hereby ordered revoked.
Okay.
Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
I think at this time,
Okay, I'm gonna need an order. Contempt. You got 93 on that. His bond's been revoked. It's 0, and he's got a preliminary examination. Good luck, Judge Washington. Court calls the case, People versus Jaquan Turner. You probably don't want to come out here right now, do you? No.
The back today, Your Honor.
Yes, that's the bond.
There's strangulation case in a DB third. When he was arraigned on June 13th, 2020, he called his friend, then after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out. So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
But
Yes.
Mr. Crater.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
There were calls made to the victim.
I can't represent that.
Correctly.
I haven't heard them. I haven't heard them.
I guess I want to make sure I'm hearing what think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right, so I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client if that did happen, he's not to have any contact with the victim. He's not to contact her or have a third party contact her in any way or fashion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the first I've heard of it.
Go ahead, go on.
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail
So
costs.
he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case. Is that what you're representing to the court?
If I could have a moment, Your Honor.
Yep.
I'm sorry. Did you tell him to call the witness? Did you say that? Did you say that? So you did do that? Yes. Okay. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact the complaining witness in order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim. He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor. I hear you. I can't hear you. Sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond and just willfully violates. Defendant's bond is modified. Defendant's remanded. Defendant's bond will be set in the amount of $100,000 cash share.
Thank you, Your Honor. Oh, I'm sorry, Judge.
Your Honor, Ms. Convertino and I are both available. I'm sorry, I knew her as Miss Joseph, and I said still when I try to call her Judge.
Okay.
We're both available on the 9th.
So? No.
At least you have water now, Judge. You know.
Yeah. All the
You sure
simple.
it's just water?
Wow. Really? Wow. Goldstein said that. It is water. And now we're going to make him drink. Preliminary examination in person. Wow, David. July 9th, 2024, 9 a.m. before Judge Burke.
Yeah.
Thank goodness that was not me. For David's sake.
And my client's sake.
No, he would have been fine. You would have had problems. All right, bond will continue.
Thank you, Judge.
There is one
Okay.
issue.
Yes, sir.
Detective Luke obtained a search warrant for the defendant's DNA. They attempted to effectuate that in the jail. The defendant refused to comply and would not let the detectives take the buccal swab pursuant to that search warrant. They are present here today. I'd ask that either the court could order him or it could be effectuated up here. The best way to handle that, but they were running into issues with the ability to obtain his DNA.
Judge, I don't think the court needs to order it at that time. At this time, I've spoken with my client about it. He will provide his sample today pursuant to the search warrant.
He'll do it right now. You guys can go back there. You can do it. Let me know before I continue to respond on this case or have the 7th or the 9th as the day. I want to make sure that that has occurred because otherwise I'll start moving things around and readjust the bond in this matter. So what do you expect me to do? In another court where?
I believe it's Wayne County. I could be wrong.
Who's his attorney?
Green Johnson.
Sir, I don't have your attorney. He was here on Zoom. I don't have him here. I don't know where he is right now. I'm gonna send you back. We'll get your case called today, right? And either it'll be with this attorney or somebody else, because I'm not putting up with this.
Okay.
Got it?
Yes, sir.
Bond continues.
Well, Your Honor, it appears we
Go
are,
ahead. You want to argue bond?
I do, Your Honor, and
for
it appears we are here on a bond violation as well. I don't know if that's what the docket said is. And the only information, Your Honor, I have with regard to the bond violation was that he was taken into custody on an alleged no contact violation that occurred at his house, where my client advises that the complaining witness showed up. He asked to leave. The police got involved. He was taken into custody as a result. I don't know exactly how that all came about. I believe that some yelling occurred. The police were called. He was taken into custody as a result. Your Honor, he does reside in a home with where he lives without the complaining witness. He is asking for some consideration there. He understands that he's not to have any contact as far as I'm concerned. And as far as I know, he did not intend to have contact that day. She came over. It was inadvertent in that he now knows that he cannot have the contact. He does have a 3-year-old daughter. He shares custody with the child's mother.
Did you request a hearing on that? Because I had already, I think, addressed this.
I thought you may have
increased his bond at the last hearing.
That was our impression too. I don't have any additional information if there was additional violations or anything alleged. I don't see anything in our file from community corrections indicating that there were additional violations. I was under the impression that this was addressed when Ms. Hughes handled it.
I thought it may have been too, Your Honor. I just saw that it was set for a bond violation hearing today as well, and I did want to put up a bond argument on behalf of my client. I would ask. He has been in jail for the last 9 days, Your Honor. I would ask for home confinement if the court would consider that. He knows he can't have contact with her. He didn't intend to that day, and he, for all intents and purposes, wants to keep that contact from happening.
Okay, having heard nothing different from the last time, there's nothing that's going to change the court's position in the bond in this case.
Okay.
This motion for bond reduction is denied. Bond will continue. Thank you.
Oh, Your Honor. Finally, I just real quickly, he is on a tether. I don't know that since he's in custody that's necessary. If we could at least have that taken off or some consideration for that to be taken off of him.
We'll leave that to jail.
The jail.
He's now.
Your Honor, the jail is leaving that to the court, is what I've been informed of. The jail won't do anything without an order from the court.
I don't know. I don't see that he has any other cases pending. So
I don't know that. I don't know. Is this the only case that he's got a tether on?
This is the only case that he has a tether on.
Well, they can take the tether off. They want the tether back. I don't care. He's not going anywhere.
Thank you.
If he leaves, he has to have the tether put
Understood.
back on. He understands that.
Thank you.
Your Honor, today is
Before I forget, happy birthday tomorrow.
Thank you, Judge. I appreciate that.
Yeah.
You know, I feel like now, like that I got a happy birthday from a celebrity judge like you. I feel like that makes me a celebrity defense attorney by proxy, right?
Wow. Wow. Here's what.
I feel very blessed.
No, I don't know what you did. My staff, it's all over my calendar. I woke up this morning, I saw it on my calendar, I said, who the heck is this? I don't even, but anyway, okay. Well.
But you didn't know my name. I'm a now. No, I'm kidding. But
I'm not biting on that. Go ahead.
Today is the date and time set for PCC. At this time, Your Honor, we would like to request one more PCC to see if we can reach a resolution in this. And I would also like to address bond.
Okay, how much time are you gonna need to see?
1 week or 2 weeks, whatever is well, the second one would be the fourth. So 1 week, please, Judge. Because it would either be 1 week or 3 weeks, correct?
1 week, 3 weeks. I also have July 2nd.
We'll do 1 week. 'Cause I'm here next week if that works for Your Honor.
Doesn't, but what the heck?
Thanks.
June 27, 2024, 9 a.m. Bond continue. Well,
Yes, Judge.
Bond.
Bond in this matter is currently set at $10,000, 10%. My client is not able to post that. When we were here last week, there was 2 additional bonds. Those bonds were both lowered to $1 each. My client cannot, and not in this case, Judge, in a different matter. So, Your Honor, my client, I did talk with him. He is able to post $100. So, if Your Honor would consider lowering to $1,000, 10%, he would be able to make that.
Any response from the people?
Thank you, Your Honor. When my office charged this case, we requested 15,000 as his bond, and defense counsel is correct. It was currently set at 10,000, 10%. At the time that he was arrested for this case, he was in bench warrant status for 2 cases. What's notable about the bench warrant status is that he had been in bench warrant status since August 12th, 2019. In one of the cases, it was his 3rd failure to appear in a row on that file that bench warrant then issued, and then he just remained in the wind since 2019. In the other file, his failure to appear to his other warrant was actually for him failing to appear for a violation of probation hearing. So this is not a person who does well out on bond. This is not a person who typically follows court orders, and absconding for multiple years with 2 warrants out for his arrest, he was in possession of a gun. So, Your Honor, at this time, I believe that reducing the bond even further would not be appropriate, especially given that.
Your Honor, if I may just briefly respond. With this case, there are 3 defendants. There was 1 gun allegedly in a vehicle. 3 people have all been charged with CCW. So possession at this point is just an allegation. And then further, Your Honor, if coming to court would be the issue, which I completely understand from what Ms. Hughes just placed on the record, I think a GPS tether would suffice in letting us know his whereabouts and that he would be here at court.
Well, at this point, we're set for next week. I'm going to deny the motion for bond reduction. I'll just keep it the same at this point. We can take a look at it depending on if there's something.
Thank you so much, Your Honor.
Thank you. As to bond.
Yes, Your Honor. We are asking the court to respectfully reinstate my client's bond or consider issuing a bond perhaps in the amount of $10,000 with 10% provision. There were 2 issues regarding his bond. It's my understanding there was a bond violation for some missed tests and also for a violation of the no contact order. Spoken with my client about both of those allegations, and he does admit to both. He indicates he did violate the no contact order. I would like to give the court some background on that. However, the date that he violated the no contact order, he indicates that he received a text message from the complainant saying, "Come grab your stuff," from the home. He went to grab his items from the home, and an anonymous caller then contacted police indicating that he was present at the home. And so, yes, he did have contact. He did go to the home, and that is the circumstances surrounding that. With regards for the missed tests, he has simply put no excuses for those. We've discussed the nature of this case and how serious it is and that he does need to test. He will be testing in the future. He will not have any other issues with testing. He has indicated to me, should he be released, he would reside in Belleville with his father and his stepmother. He will also be working with his father. They do fencing, installation, and repair. So he will have gainful employment as well as family support.
Not sure I'm going to need a response because the problem, I hear what you're saying, counsel. Problem is he was supposed to be testing. He's not. He's been missing his testing. And the other thing is that he is apprised at the time of arraignment that if he needed to get his items, then certainly he could do that by use of a civil standby, and he failed to take advantage of that, and decided to engage in self-help. So his bond will not be reduced to what you're asking. I will set his bond at a $50,000. I'll give a 10% privilege on that, but
10%, 50,000, 10%, 9,000. Okay.
all other conditions remain in place.
Thank you, Judge.
That was a waiver, so I think she needs to sign something. Court does call the case People versus Counsel. You guys are gonna have to not talk to your client when they're on their way out. These guys gotta move these people in and out. Court calls the case. You're not the only one that did it, Ms. Constantino. It wasn't at you. But yours was most egregious. Court calls the case People versus Tyler Stafford.
Briefly address bond. Be very quick.
Go ahead.
Your Honor, Mr. Warren's bond is currently set at 10,000, 10%. He is unable to post that bond. To my understanding, his only prior is resisting and obstructing from 2010. He did have, I believe in this case, he did have a prior failure to appear. He was in and out of hospitals. And that's why he wasn't able to be brought in. And then he did rehab and completed rehab twice successfully. We've talked about this. He will show up at all future court dates. He does want to get this.
How did he come back into custody?
Pardon me?
How'd you come back into custody?
I was at the Ann Arbor Comprehensive Outpatient Rehab, and they picked me up. The police picked me up.
So you didn't turn yourself in?
No, that was on my agenda.
Yeah, I'm sure it was. Anything else?
Nothing further.
Motion for bond reduction denied. What's that? What's that mean? Aren't you keeping track? All right, I'm done. Court stands in recess.
All rise.
Wow, this water was good. Part-time Ron Brown or Lauren Brown.
I was hard at work, Your Honor.
No, they told me you were gone. Actually, the way the whole conversation went is he's gone. You know, he don't work the whole day. Actually, the person I think that said it was Childers. Yeah, that's when he said, "Oh, he's long gone." Yeah, he just said Lauren doesn't work the whole day. I will say this also, Mr. Brown.
One of them said.
No, it was Childers. It was Childers that said it. I will say the thing that I was shocked about was that Joy Gaines did not jump to your defense. She did not. She absolutely did not. Hey, that's it for that block? Wow. Emily, you are the bastion of efficiency.
I know.
Wow. And humble. All right. Court is standing in recess.
All rise.
Hello.
Hi.
She's here.
I'm
All
back.
right. You're back. All right.
I was with you this morning, too early.
Yes,
remember?
ma'am. No, I remember. You were here at like 9.
I just like
All
watching
right.
your courtroom. I'm just gonna log in every day because you crack me up.
Okay.